The required Scotus cases. We're starting off with number 1, Marbury v. Madison. So obviously, well, not obviously, but denied Marbury's commission, but established judicial review, had the court's power to invalidate unconstitutional laws, and the decision shifted the balance of government by making the judiciary a co-equal branch with authority to interpret the Constitution. So it gave it like power and stuff. Federal supremacy, McCullough v. Maryland. So it affirmed Congress's implied powers via the necessary and proper clause, and it also held that states can't tax federal institutions under the supremacy clause, and the ruling expanded federal authority and reinforced national supremacy over conflicting state actions. United States v. Lopez. So the court ruled that Congress exceeded the Commerce Clause by criminalizing a gun on school property, marking the first significant limit on federal commerce power in decades. So they tried to say that, hey, this falls under the Commerce Clause and whatever, boom, 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 right? But obviously this has nothing to do with commerce. I feel like it could be used for almost like for a lot of things, right? That commerce thingy, but in this case, they didn't let that slide, right? So the decision reasserted states' power by confirming that not all activities fall under interstate commerce regulation. So they were like, can't do that. Individual rights and liberties. Moving on. So free speech limits Schenck, and we got Tinker. So in Schenck v. United States, it introduced the clear and present danger test. It permitted restrictions when speech poses an immediate harm, especially during wartime. So the dude was like frickin', passing out these flyers and stuff like that, right? And there was a great need for, soldiers and stuff, right? So I guess him trying to discourage people from doing that, from joining the war and whatever, was probably a clear and present danger, right? Tinker v. Des Moines, it protected student expression unless it materially disrupts school operations, and it affirmed that students retain First Amendment rights even past the school gate, right? So once you're on school grounds, your rights don't stop there, right? Like you still have rights. So basically, unless you're disrupting, school operations, meaning you're being loud and you're, being an asshole, you're chilling. They were wearing armbands. It was, quiet protest. Equal protection, Brown v. Board, and we have Shaw versus Reno. So in Brown v. Board, it declared that separate is inherently unequal, using the Equal Protection Clause to dismantle legalized school segregation. And in Shaw v. Reno, it limited race-based redistricting, holding that racial gerrymandering was unconstitutional when race is the predominant factor. Criminal due process rights, Gideon and Baker v. Carr. So in Gideon v. Wainwright, it established the right to counsel under the 6th and 14th Amendment, requiring that states provide attorneys in serious cases. And in Baker v. Carr, it made redistricting claims justiciable. Enabling federal courts to address, I don't know how to pronounce it, and protect voting equality. So we're gonna go over these things. Extra. So what case established judicial review? So the case that established judicial review was Marbury. Why? because the court said that the law Marbury relied on conflicted with the Constitution, so they refused to enforce it. And by doing that, they basically said, we have the power to declare laws unconstitutional. That power equals judicial review. Which case created clear and present danger? It was Schenck. Why? Well, because Schenck's anti-draft speech was seen as dangerous during wartime. The court ruled that speech can be limited if it creates a clear and immediate danger to society, like interfering with the military. That's where the test came from. Which case said students have rights? Tinker. Why? Tinker said that students have rights because students were punished for wearing armbands, which was symbolic speech. The court said that students do have First Amendment rights at school, but only as long as it doesn't disrupt learning. Which case ended segregation? Brown v. Board. Why? The court ruled that separating students by race is inherently unequal, violating the Equal Protection Clause of the 14th Amendment. This overturned the separate but equal doctrine that was in Plessy v. Ferguson. And then we have which case limited Congress? That's going to be Lopez. Why? Because Congress tried to use the Commerce Clause to regulate guns in schools. The court said that bringing a gun to school is not interstate commerce at all. So Congress went too far, meaning that their power does have limits, even though that dude was in the wrong for bringing a gun to school, right? Which case incorporated rights to states? So it's not only one. It's going to be two cases, Gideon and McDonald. Why? Well, both use the 14th Amendment, the Due Process Clause, to apply rights to states. Number one, Gideon, right to a lawyer, 6th Amendment, must be provided by states. McDonald, right to bear arms, the 2nd Amendment, applies to states. The process is called selective incorporation. The next one, which case deals with prior restraint? This is going to be the only case that deals with prior restraint. Why? Well, it's going to be New York Times v. United States. Why? Because the government tried to stop publication before it even happened, which was the Pentagon Papers. The court said that that's prior restraint, and it's almost always unconstitutional. The press is protected under the First Amendment. Stuff to remember. Marbury is court power. Schenck limits speech. Tinker, students' rights. Brown v. Board of Education is equality. Lopez limits on Congress. And Gideon and McDonald applying rights to states, and New York Times protecting the press. So that's about it. Yeah, I feel like I could have added more, but yeah, you can just kind of go back and review that. I'm gonna, on the next video, I'm gonna try adding questions to kind of like prep for stuff. But this is a really late video. It's 2 a.m. right now, currently, so took me a bit to make the slides and all that, but that's about it. Yeah, see ya.